Welcome to Week 2, Analyzing Rulings. During this week, you've read the required readings and case law in which you firstly analyzed the effect of the decision of Gaba versus Minister for Safety and Security 2010 and the significance of precedent in relation to labor law matters, and have understood the meaning of separation of powers. You have further assessed the content of rulings with reference to 3 cases, being Assigned Services, Pty Limited versus CCMA and others 2015, including the Constitutional Court decision in this matter, and thirdly, Lad Brokers Pty Limited versus Mandla 2002, and lastly, you have critically commented on the case of David Victor and 200 others versus CHEP South Africa Pty Limited and others 2019. The decision of Gaba versus Minister for Safety and Security 2010 is an administrative law and its incarnation after the promotion of Administrative of Justice Act 2000, PAJA, has no application to public sector employment. The case dealt with the application for leave to appeal relating to the powers of the High Court over labor-related matters and whether the conduct of a public sector employer towards an employee amounts to administrative action. A unanimous court held that jurisdiction must be assessed on the basis of the pleadings. Where remedy lies in the High Court, Section 157(2) of the Labour Relations Act 66 of 1995 should not be interpreted to exclude such jurisdiction. However, employment and labour relationship decisions taken in relation to public sector employees generally do not amount to administrative action. When conduct of the states as employer has no direct consequences for other citizens, it will not amount to administrative action. Accordingly, the application was dismissed and there was no order as to costs. However, before Gaba, the courts had not squarely confronted a fundamental issue concerning the relationship between labor law and administrative law. And at the time when PAJA was enacted, the legislature was aware of the existence of the Labour Relations Act, with its application to public sector employment contracts. Despite this, the legislation in promulgating PAJA did not expressly exclude decisions in this sphere from its reach. By not expressly excluding employment contracts from PAJA's reach, the legislature made a policy choice. Therefore, the significance of precedent in relation to labor law matters is important in that it is unavoidable that judges will encounter legislative choices with which they disagree. It could be valid or coherent grounds for such disagreement, but the court, being the court of last instance, has a duty to respect the policy choices of legislature. That requires an appreciation of the distinction, which is often nuanced and not apparent, between questions of legal interpretation and policy choices. At its very core, the problem identified by the court in Gaba was not one of judicial interpretation, it was one of the undesirability of the consequences of giving effect to a given legal regime. That a particular normative order brings about undesirable consequences does not make it constitutionally bad. Therefore, the duty of the appellate constitutional court lies in not taking sides in the debate of who is right or wrong, but in what is legally permissible. Ironically, Gaba's future lies in the very doctrines that had sought to undermine stare decisis and separation of powers. It is said that its survival depends on whether a future court will defer it on the basis that it was decided after the Fredericks case, or it takes a view that it was wrongly decided and therefore should be overturned. The Constitutional Court decision. Before the Constitutional Court, among Assigned's arguments in support of dual employer interpretation was Section 1982 had not been amended after the introduction of Section 1983b, which supports the legal notion that the Labour Relations Act foresaw 2 employers under these circumstances. A worker's rights are better protected by having 2 employers as opposed to a situation where the worker's employment contract ends with the tests, whereafter and without the worker's consent. they enter into a new employment relationship with the client on new terms and conditions. NUMSA, on the other hand, argued that Section 198 and Section 198A should not be read in conjunction. Each section contemplates different realities. Section 198 applies to employees placed by a test and who earn the annual threshold, while Section 198A applies only to placed workers earning below the threshold. Thus, there is no need to reconcile Section 198 with Section 198A. On the sole employer interpretation, once the employee becomes an employee of the client, their working conditions could only improve by virtue of Section 198A(5). The court went into an extensive analysis of how legislation, and in particular Section 198A(3)(b), should be interpreted, and found that from a contextual and purposive interpretation, the sole employer approach gained support. Having done so, the court addressed the triangular relationship between the test worker and client and found that the test's duty as employer were generally limited to placing a worker at a client and paying the worker from proceeds received by the client. It is the client who exercises authority over the worker by determining their working conditions, duties, performance assessments, and who has the authority to discontinue the worker's services. Therefore, the test merely delivers the worker to the client. On the basis, the court rejected the argument that a sole employer interpretation forces the worker, without their consent, into a new employment contract with the terms and conditions. The change in employment from the test to the client is not a transfer of new employment relationship, but rather a statutory change in respect of the designation of employer within the same triangular relationship, which continues as long as the commercial contract between the client and the test remains in force. This change in employer does not adversely affect the worker who continues to perform the same work under the same or similar working conditions. In dismissing the argument that a dual employer relationship offered better protection for a worker, the court held that the sole employer interpretation provided certainty and job security. In addition, and from a practical point, the dual employer interpretation created potential problems, such as the employee being subjected to two disciplinary codes, which may categorize misconduct and poor performance differently. If dismissed, which employer dismissed the employee? Which employer must reinstate the employee should the dismissal be deemed unfair? Moreover, while employees might have a legitimate interest dispute against the tests, which would enable them to embark on protected strike action, the same dispute might not be a legitimate reason to strike against the client, which leaves the employees vulnerable to dismissal. In conclusion, the court held A. Section 198 deals with the general position with regard to TESs, while Section 198(2) is a deeming provision creating a statutory employment contract between the TES and a temporary placed employee. B. Section 198 deals with the application of Section 198 to a specific category of workers, being marginal employees employed below the Basic Conditions of Employment Act threshold. C. Section 198(3)(a) provides that when vulnerable employees are performing a temporary service as defined, they are deemed to be employees of the TES as contemplated in Section 198(2). D. Section 198(a)(3)(bi) provides that when vulnerable employees are not performing a temporary service as defined, they are deemed to be employees of the client. E. The deeming provisions in Section 198(2) and 198(a)(3)(bi) cannot operate at the same time. F. When marginal employees are not performing a temporary service as defined, then Section 198(3)(b)(2) replaces Section 198(2) as the operative deeming clause for the purposes of determining the identity of the employer. The appeal was thus dismissed with costs. In a dissenting judgment, Kachalia A.J. concurred with the dual employer interpretation. In this case of Lad Brokers Pty Limited versus Mandla 2002, the court held that the worker was the employee of the TESS, which it concluded was due to the remuneration structure between the TESS and the worker. The court, however, held that while the TESS is the worker's employer, the TESS and the client are jointly and severally liable if the TESS contravenes a bargaining council agreement regulating terms and conditions of employment, an arbitration award, the Basic Conditions of Employment Act, or a sectorial determination. This case is of great importance because it created an interest for the potential liability of clients and forced them to ensure that certain rights were upheld in favor of the workers, in fear that they could, for the first time, incur liability if certain obligations were not met. This week's learning outcome will form a valuable foundation for the weeks to follow. You are encouraged to read further on any additional readings if you can, including the readings and case law required for this learning unit, in respect of drafting your PowerPoint slides and critically commenting on a case on Wiki with your peers, and further to do a multiple choice question in relation to your reading. Join me for the next week as we draft rulings part 1, dealing with an introduction and issue.